Pick a page at random, tell me the number, and I will tell you exactly what their client did to them.
Here we go. She's going to do it, obviously.
627, Mr.
Lawrence Green.
I mean, this is pretty cool, though, right? So today we're going to break down a scene from Suits.
Mr. Zane, you scheduled this hearing. We've been waiting 10 minutes. I'm not waiting any longer.
Okay, first of all, parties don't schedule the hearings. The court schedules the hearings. So when you submit your paperwork, whether it's a motion or a pleading or anything that requires an oral argument, the court schedules it. The court tells you when to show up. You don't tell the court when the parties should show up. So right off the bat, that makes no sense.
Well, you don't have to, Your Honor. My motion is here.
Better get up here fast.
Second of all, that paperwork is filed far in advance of that hearing. There's something in New Jersey called return dates. That is the date that the court will most likely rule on that motion. You don't submit the motion the date of your motion because the other side needs to have an opportunity to respond, whether it's a rebuttal or, a letter brief, but you have to have an opportunity to respond to whatever motion that the moving party is making. So by handing over a folder the day of the motion hearing, I can tell you in New Jersey that would never happen. The court will not even schedule a date without all of the proper paperwork filed.
What the hell were you? I'm standing up here with my dick in my hand and you're out having a soda.
I had something to do.
Yeah, well, whatever it was, I was almost losing this case over.
Motion to expedite trial. I thought this was a hearing on their motion to dismiss.
Well, if you expedite our trial, that takes care of their motion to dismiss.
No. There are such things as motions to expedite trials, but in this situation, if this were realistic and the court scheduled a motion date, the parties do not now get to change the reason for that motion date into something else. If the other attorney is asking the court for a motion to dismiss, he now cannot come in and say, well, I want a motion to expedite. That's not how it works. He would have to file an opposition motion and a cross motion, not a motion entered the day of the hearing for the other party's motion. That's not how it works.
Miss.
Your Honor, they just got this case 2 days ago. They're using the timing of our client's contract expiration to try to shake us down.
I have to say, Mr. Zane, I find it hard to believe that in 2 days you found out enough to know you need an expedited trial, let alone care about these people at all.
The first part of her statement, I would agree with. 2 days is definitely not enough time. This sounds like a very complicated civil litigation matter where there would be a ton of discovery. But number two, I don't believe a judge would ever comment on whether or not an attorney cares for their client or cares for the party. So that's a little strange and a little theatrical.
Your Honor, 4 years ago, a mail carrier named Stanley Powell felt tightness in his chest. He thought it was nothing, but his wife insisted he go to the hospital. When he got there, doctors...
I just realized something. Nobody put their appearance on the record, so the record has no idea who's speaking. That is very simple. The attorney for the plaintiff would stand up, they would say his or her name, put it on the record, who they represent. They would sit down, and the attorney for the defendant would stand up, put his or her name on the record, and so on and so forth. One of the duties of the judge is to make the record clear. So here, the judge kind of failed at that.
Couldn't find anything wrong, but they wanted to keep him for 1 extra day. Now, unfortunately, Kelton Insurance refused to pay. So Mr. Powell went home, crawled into bed, and 1 day later he was dead. Now, in front of you, you have a complaint that's over 5,000 pages long, which tells the stories of another 189 victims.
Okay, first of all, there are requirements on how many pages can be submitted in a complaint. And I've done thousands of litigation cases. I've never seen a complaint 5,000 pages long. So that's a little ridiculous. So that's also incorrect.
Pick a page at random, tell me the number, and I will tell you exactly what their client did to them.
Your Honor, are you actually buying that?
Here we go. She's going to do it, obviously.
627, Mr.
Lawrence Green, 63-year-old grandfather, admitted to St. Vincent with complaints of lower back pain and excessive.
I mean, this is pretty cool, though, right?
Stress. Turns out it was lymphoma. Only they didn't find out until it was too late because their client refused to pay for the MRI. So please, rule against us if you have to, but don't tell me we don't care.
Motion for expedited trial granted. Jury selection starts Monday.
So let me get this straight. You have a 5,000-page complaint. It doesn't sound like any discovery was done, and you're asking for an expedited trial. That makes no sense. This sounds like a class action lawsuit by a number of plaintiffs who were detrimented by the insurance company's refusal to pay claims. On its face, it sounds pretty legitimate, but people don't realize that there's something called discovery in litigation. That's when all the facts come out. Discovery involves notice to produce, which is basically production of documents, interrogatories, which is basically questions that are asked of the other party. You have to answer those questions, sometimes in detail, sometimes they're yes or no. And you have depositions. Depositions are the opportunity for the parties to ask questions, whether in person, now they're being done over Zoom, concerning the case. If there are hundreds of plaintiffs in this case, then the insurance company has a right to depose every single one of those parties. That would take a long time. In no way, shape, or form would the court ever allow an expedited trial in a situation like this.
Monday.
For your information, that's what I was doing. And it only took as long as it did because I was also doing something for the one person who has the right to treat me like his associate, but treats me like his partner anyway.
Well, if you can forgive me, what do you say I take my partner out to lunch?
Mr. Evans, is it true that you were living with Mr. Ross in and around the time he claims to have attended Harvard?
Yes, we shared an apartment at 5307.
So right off the bat, in the show, it was clear that Mike Ross did not go to Harvard. That would be something called an undisputed fact. When both parties submit their submissions for trial to the court, it's called a trial brief. Usually in the beginning parts of the trial brief, there would be something called undisputed facts, where both parties get together and say, okay, let's agree on these facts so that we don't need to go through testimony. One of those things would definitely be, without a doubt, that Mike Ross did not go to Harvard. That is a fact that is easily provable. I'm not sure why they would try to dispute that, but what they're doing through this testimony is to try to hammer in on the fact that he obviously didn't go to Harvard.
07 Huntington Boulevard in Brooklyn.
And how exactly did he pay his rent?
He worked as a bike messenger and made money on the side taking the LSATs for people.
Oh, wait, I'm confused. Why would he have to resort to that if he were a college graduate?
Because he wasn't a college graduate.
What? You mean he never graduated from college?
No, he was kicked out of college for cheating on a test.
Well, isn't it possible that while he was living with you, he went back to school and completed his degree?
Well, I don't see how, since most of his spare time is spent sitting around smoking weed with me.
Well, let me get this straight. Before he was employed at Pearson Spector, to the best of your knowledge, he worked as a bike messenger and a part-time LSAT imposter?
Yes.
One last question, Mr. Evans. Is it at all possible that Mike Ross ever attended Harvard Law School?
Not unless I had a satellite campus at 5307 Huntington Boulevard in Brooklyn.
No more questions, Your Honor.
Given that you smoked all this pot, Mr. Evans, isn't it possible?
Now it's Harvey's opportunity for a cross-examination. Typically, in most cross-examination situations, the attorney would ask very leading questions, very pointed questions, and they would most likely be yes or no questions.
Ross commuted 1 day a week to Harvard Law. You might not remember that?
I'd remember.
Yeah, maybe you would, but you'd lie through your teeth about it anyway, wouldn't you?
Objection.
Mr. Evans, isn't it?
Okay, objection what? First of all, she objected. She has to have a reason for objecting, and then the judge would overrule it or sustain it, meaning the judge would either let the question go in or not allow the question at all and strike it from the record and not allow the jury to take that question into consideration. All she said was objection, and then Harvey continued on with his monologue.
True that you're a longtime drug dealer and your testimony today is only happening because you signed a deal with...
Another thing is that your cross-examination needs to be within the scope of the direct examination. Here it's a little gray, but if the plea deal was never spoken about in the direct testimony, then he cannot talk about it in the cross-examination. So this line of questioning would not be allowed.
Miss Gibbs giving you immunity?
Doesn't mean I'm lying.
Because you wouldn't lie just to get out of going to prison.
No, I would not.
Well, how about if the other reason was to get back at someone you've been jealous of your entire life?
I've never been jealous of Mike Ross.
This has nothing to do with the direct testimony of the witness. This would never be allowed. And if I were the other attorney, I would object and I would say that this is not relevant and this is out of the scope of the direct testimony. I would ask for it to be stricken from the record. In fact, I would probably ask to conference the case with the judge and request that the other attorney be held in contempt if he continues with this line of questioning.
In my entire life.
And I just caught you in a lie.
Objection, Your Honor.
Mr. Evans, my next move...
Again, objection what? You can't just blanket object. You have to have very specific reasons. One of the judge's main duties is to keep an accurate record, and if any party wants to appeal, that record's going to be pulled and looked at. If the attorney objected on something and the moving attorney feels like that objection was incorrect, then they need to reserve for a right for an appeal to bring that part up. But if she didn't even clarify why she objected, then it's all nonsense.
move is going to be to call Jenny Griffith to the stand, and she's going to testify that you lied to her for years.
When you go to trial, each party has a witness list, and everyone knows ahead of time who is going to be called as a witness. There's no surprise witness. The witness doesn't show up on the day of trial, and it's not a surprise to everyone. You need to have an opportunity to cross-examine that witness and anticipate any issues that witness may bring. In addition, you need to have an opportunity to object to that witness testifying at all. So that would not happen.
About dealing. When she found out about it, she left you for Mike Ross.
Objection, badgering.
She's also going to say that you were jealous of his mind your entire life.
She didn't even give the judge an opportunity to rule on the objection. So she just said objection badgering, but the judge did not rule on it. So he continued on with his line of questioning. That would not happen.
And when you found out that she left you for him, you were as jealous as a human being can be. Now, is that true or not?
Your Honor.
Let me rephrase. Is Miss Griffith going to be perjuring herself, or are you?
Yeah, I was jealous of him.
And if he lied about all of that, what's to make us believe that he wasn't lying about everything else?
So there are some exceptions. You can attack the witness's credibility for the purpose of impeachment. Basically, you want the court to not find them credible, and you want the jury to not believe anything they said. Sure, that's what Harvey did here, but he went about it totally the wrong way.
No further questions, Your Honor.
Your Honor, prosecution calls Donna Paulson to the stand.
Don't worry, Donna. She won't ask you point blank if you knew Mike was a fraud. What if she does? If you lie, they'll never know.
If you're a fan of Suits and you want to see me dissect more scenes from Suits, please comment down below with the exact scene and clip, and I'll be sure to do so.